Hello, my name is John Brooksby, and I have been assigned the case Nassau County versus Arline, and this is in regards to a disability discrimination. This is a Supreme Court case that took place in 1973. It presents the questions whether a person afflicted with specifically tuberculosis, a contagious disease, may be considered a handicapped individual according to Section 504 of the Rehabilitation Act of 1973. First of all, to give a little bit of background and to establish what Section 504 of the Rehabilitation Act says, it specifically prohibits a federal-funded state program from discriminating against a handicapped individual solely by reason of his or her handicap. Specifically, it goes into saying, in pertinent part, no otherwise qualified handicapped individual, that we'll go into more of that definition, in the United States, as defined in Section 706 of this title, shall solely be reason of his handicap be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. And going into that, what a handicapped individual means, because that's what they base it on, or what they base her case on, is that any individual who has a physical or mental impairment which substantially limits one or more of such person's major life activities, has a record of such an impairment, or is regarded as having such an impairment. So that having a record of such an impairment, that is what they base this case on later on. But to give you so here's the situation. Jean Arline taught elementary school and was discharged after suffering a third relapse of tuberculosis within 2 years. She brought suit saying that the school board's decision to dismiss her because of her tuberculosis violated Section 504. The Court of Appeals held that persons with contagious diseases are within the coverage of Section 504 and that Arline's condition falls neatly within the statutory and regulatory framework of the Act. And going back to what I had mentioned about having a record of the disease or the impairment or handicap, she had gone to the hospital, and just by going to the hospital and being hospitalized, that satisfied the requirements of having a record. The ruling of the court, as what we just read, is that we conclude that the fact that a person with a record of physical impairment is also contagious does not suffice to remove that person from coverage. Reasoning for the ruling was that the fact that some persons who have contagious diseases may pose a serious health threat to others under certain circumstances, does not justify excluding them from the coverage of the 504 Act. All persons with actual or perceived contagious diseases, if that were the case, such exclusion would mean that those accused of being contagious would never have the opportunity to have their condition evaluated in light of medical evidence and a determination made as to whether they were otherwise qualified. Rather, they would be vulnerable to discrimination on the basis of mythology, precisely the type of injury Congress meant to prevent. They finally said that we conclude that the fact that a person with a record of a physical impairment is also contagious does not suffice to remove that person from coverage under 504.